Good afternoon. I'm Dr. Jana Martin, Chief Executive Officer of the American Insurance Trust, known to most of you simply as the Trust. We're delighted that you're able to join us virtually today for this webinar. As a trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of many benefits our insureds receive through the Trust. 3 of our advocates are with us today, Drs. Julie Jacobs, Mark Martinez, and Lisa Bryant. I hope you benefit immensely from this risk management roundtable. Please join me in welcoming Drs. Bryant, Jacobs, and Martinez. It's all yours.
Great. Thanks so much, Jana, and welcome to all of you. We are thrilled to be back with you. As usual, we will start with a few some questions that we get from callers in advance, and then we will start diving into the live Q&A. And as Jana said, even while we're talking about those first few questions, if you want to go ahead and start popping your questions into the Q&A box, we will get to those as soon as we get through these. So the first question, Mark, I'll actually start with you. And this is about requests for test data and test materials that clinicians get not infrequently. So maybe can you start by just differentiating what those two things are, test data and test materials, and then let us know, if you can offer some risk management strategies for how a clinician might respond when they receive such a request.
Yeah, sure, happy to. So a common distinction between test data and test materials is provided within the APA Ethics Code. Specifically, look at standards 9.04 and 9.11. And so within those standards, what you'll see is that test data refers to raw and scaled scores, client-patient responses to test questions or stimuli, as well as the psychologist's notes and recordings regarding the evaluee. Test materials, on the other hand, refer to manuals, instruments, protocols, which is largely intended to refer to testing instructional sets and procedures. And this also includes test questions or stimuli. So test materials do not include test data per standard 9.11, which appears to be inconsistent with standard 9.04. Now, with that in mind, hopefully this will be remedied in the upcoming APA Ethics Code revision, just to make it a little bit more clear. So as an example, an evaluee's statements and responses on a waste, for instance, are generally considered test data. However, the test instructions, the questions and stimuli that are embedded within the waste response forms should be considered test materials. So beyond this distinction, I recommend that you consider your state's ethical code of conduct, which may or may not be the APA Ethics Code. And so as I noted, standards 9.04 and 9.11 speak to this distinction in the APA Ethics Code, as well as our responsibility to make reasonable efforts to maintain the integrity of test materials in a manner that's consistent with our contractual obligations, as well as the law, and also adheres to APA Ethics Code. So next, it's important to check for the presence of state-specific rules and regulations related to the disclosure of test data and materials. Not all states will provide such guidance, but for example, in California, their Code of Regulations notes, and I'll quote this, "A psychologist shall not reproduce or describe in public or in publications subject to general public distribution any psychological tests or other assessment devices, the value of which depends in whole or in part on the naivete of the subject in ways that might invalidate the techniques." It goes on to further note that a psychologist shall limit access to such tests or devices to persons with professional interests who will safeguard their use. And another sample comes from Florida and their administrative code, which happens to define test data a little bit more broadly than the APA Ethics Code by considering this to include test protocols, test questions, and assessment notes and written answer sheets. So you can see how, depending upon your jurisdiction, the definition of test data materials could be slightly different. The Florida Code also goes on to provide direction on how such information should be released, which appears to limit the scope to certain qualified professionals and when required to disclose these things by law. So beyond that, next, you want to ensure that you have authorization from the appropriate party or parties, or that you were required to disclose this information by law, such as in response to a court order. And you want to do this confirm this information before you release the test information to third parties. So in application, this means you would check with the client or patient about the request if it's made by a third party. And if you're legally required to release, such as in response to a court order, I still recommend having that conversation with the patient or client before complying with the legal obligation. And next, consider your options for meeting the reasonable effort standard as it relates to maintaining the integrity and security of test materials. So let's imagine that a psychologist provides a diagnostic evaluation using various evaluation records and tests, and the evaluee happens to have a pending wrongful termination case. And several of the tests that were used intermingle what traditionally is considered test data with test materials. And let's assume that the psychologist has authorization from the evaluee to disclose this information following a request from the evaluee's lawyer to disclose this for the litigation that's ongoing. So when you're exploring what options to take in response to requests like this, refer again to state-specific rules, regulations, and code of conduct. And some of the options you have at your disposal may include, one, redacting test materials. That would be, for instance, redacting the test questions, items, instructions, and leaving the test data intact, those notes or responses provided by the evaluee. Now, if you're doing this, I recommend that you include a written response that clarifies the reasons for redaction. Another option is to request authorization to send the test data and materials directly to a qualified professional. And this may be defined by state rule, regulation. There's also typically some guidance on who would be considered a qualified professional on the test publisher's website. If a request is made by an attorney or a court for test materials and sending to a qualified professional is not an option, I recommend that you seek a protective order from the court that details what materials will be shared, who will have access to them, how they'll be used, how the materials will be protected, so not copied, not reproduced, or redisclosed to those outside those who should have access, and how the materials will be handled after their use is complete, for instance, perhaps returning them to the original psychologist. And finally, of course, consulting with your professional liability carrier or an experienced colleague is recommended prior to deciding which option is best for you.
Terrific, Mark. You covered a lot there. It's very helpful. Julie, anything you want to add?
Just really quickly, on some of the test makers' websites, they'll actually have language that you can use. If you get a request from someone for test materials, you can actually copy and paste language that cites copyright laws and the reasons that you can't disclose certain information. So it can be helpful to pop on Parr or Pearson's website and look in their legal section. And sometimes you can actually borrow their language and use that as part of your response to explain why you may not be providing everything that's been requested.
Right. And we know that's a fair amount of information and fairly specific. So as Mark said, you know, when you have questions about this, we always recommend consulting, right? One of the main risk management strategies. So call us, talk with experienced colleagues, but definitely consult. And as you know, whenever you're having release of records, right, you want to act conservatively until you know that you have to release them. So if you don't know, you can wait a little bit until you figure it out. That's another option. So great. Thank you both. Julie, I'm going to start with you on this one. And we are getting, as you know, more calls related to ketamine assisted therapy. So let's say, as in many of the calls that we get, that a client comes into their therapist and says, you know, they've done some research and they're really excited. They have a prescription from their doctor for ketamine and they want to come into session now with the therapist and take the ketamine in session and have the therapist help them process that experience. What would you say are some of the risk management considerations that clinicians need to be thinking about in that situation?
Such a great question and such a hot topic. I'm going to start with just some basics to lay a little groundwork here. You know, ketamine assisted therapy is an emerging intervention and there's some promising research out there. So it's definitely something that's going to be up and coming as they continue to do research and sort of refine the standards of care. Ketamine use in ketamine assisted therapy is actually an off-label use for that medication, and administering or prescribing ketamine is the practice of medicine. So you want to make sure one of the important risk management strategies is not practicing medicine as a psychologist. So this is a medical intervention. It's probably safer for psychologists not to be primarily recommending this, to let this be the purview of medical professionals, but certainly can consult with a medical professional who thinks this might be an appropriate treatment for a specific client. As always, the basic risk management tools that we talk about are going to apply here. So risk management includes informed consent, competence, consultation, documentation. All of those are going to be very relevant. We'll start with competence. The scenario that you describe sort of sounds like a psychologist who doesn't do this, who doesn't have any training in this, and it's really being patient initiated. Well, you need to be competent before you engage in something like this, before you engage in any intervention, but particularly something that's this new and emerging. So you want to be able to show that you are aware of the standard of care and that you're adhering to that standard of care. So look for a reputable organization that's providing training on this and get certified or whatever the training may include, so that you can argue and speak intelligently about what the standard of care is for these kinds of interventions. It's also a really good idea to develop relationships with prescribing providers who are competent in this area. So again, not just someone who's giving a prescription to their patient because they asked for it, but someone who understands and is conversant in the research and in how to use these interventions effectively. Careful patient selection is going to be key. So you want to make sure that you have obtained relevant records and that you've screened your patients for any contraindications like active substance addiction, bipolar disorder, suicidal ideation, whatever the case may be. You need to, as always, carefully select clients for this kind of an intervention. And then informed consent. You want to outline risks, benefits. You want to outline that this is an emerging intervention, that the research is somewhat limited, that it's completely voluntary, that there are other options and alternatives out there. And then really important to outline your role, what you are and are not doing. So as I noted before, ketamine is a medicine that needs to be prescribed by a physician. You want to make clear that it is the physician who's in charge of the medical screening, of making that, of prescribing the medication, making sure that your role is clearly delineated as a facilitator to help process the experience, but not to be administering the medication or medically monitoring the patient while they're under the influence of the medication. Patients can't drive themselves home after something like this, so that should be part of the informed consent conversation. Who will be your driver? Perhaps get a limited release of information so that you can communicate to that person when and if necessary. I'm just creating contingency plans for things that can go wrong. That's what we do, right? What could happen? There could be side effects. There could be some sort of medical issue. What are you going to do in those cases? Ideally, you are not going to do much. You're going to have a medical professional to help you assist in those situations. And again, the way that the scenario is put together sort of assumes that someone's just going to pop in the office, take ketamine and have an experience. And that's not really how this works, right? There should be preparatory sessions where these informed consent conversations happen. Then there tends to be the medication session and then integration sessions after the fact. You can't really do meaningful integration while the person is under the influence. You have those sessions after the fact to talk about what it was like. And a huge way to mitigate your risk is to have a medical professional on site. You are not likely to be competent in providing medical assistance if something goes wrong. I mean, I suppose there are some folks out there who are MDs and psychologists, but for the most part, you're going to need some support. And you really want to divide those roles appropriately. So having a medical professional on site, if not in the session, at least in the building. So if something goes wrong, you can have immediate response and perhaps even an agreement with that medical professional in terms of what will your role be, what will their role be. If there is any kind of agreement with the physician or medical professional, make sure that it's appropriate and it doesn't allocate an appropriate level of responsibility to you as the psychologist. And then documentation, document. And in this situation, you're going to document in advance of the intervention. You know, we usually document what we did after we did it, but here you're going to document all of the plans and consultations and things you've done up front to make sure, you know, it's clear why you think this is an appropriate intervention. You want anything that you want the licensing board to know to be in that documentation. So those are just some of the basics. This is a huge field. There's a lot to talk about, but I think in the interest of time, I'll stop there.
Well, you covered a lot, Julie. That was really helpful. I think you hit a lot of the big points. Mark, anything you want to add there?
No, I think Julie did a great job uncovering the relevant issues here. And one of the things that I think the information she disclosed was emphasizing the importance of preparatory work. That's trying to anticipate what potentially could go wrong and trying to come up with mitigation strategies ahead of time. And the informed consent, one of the things that I will often recommend is putting that draft together, having it in front of colleagues, getting a critical eye and commentary on that document. And if I always also recommend getting it in front of an attorney in your local jurisdiction, so they can critique it as well. So I think that's all very helpful information, though, Julie. Yeah,
that's great. Thank you to you both. So Mark, coming back to you, and this one is regarding subpoenas. If a clinician, say, is subpoenaed in, let's say, to provide testimony for a patient that they've been treating. So this is not a forensic issue, right? This is a clinical therapist who's been treating a patient and now receives a deposition subpoena, a subpoena to testify in court. What kind of risk management strategies do they need to think about in that situation?
Well, first, I understand completely that many psychologists out there try to avoid involvement in court-related matters. And it's sometimes a request that arises anyway, unfortunately. And I also appreciate that many psychologists will include language in their informed consent regarding a patient or client's agreement not to involve them in legal matters. And while this may discourage the clients or patients from this happening, it's unlikely to offer much protection in the long run. So just keep that in mind. If subpoenaed for testimony, discuss the request with the patient and client. I think that's an important first step. Remind them of your role, what you can and cannot speak about, and any foreseeable risks that may accompany testimony should it occur. Among these is the potential for a therapeutic rift, how certain information may be damaging, hard to hear, or contrary or unfavorable to the patient or client's case. So in other words, when you have this discussion with a patient or client, provide them with sufficient information so that they can make a decision whether to authorize the release of treatment information. Now, after that conversation, a client or patient may wish to assert privilege, which may protect against the requested information being disclosed. And this depends upon the jurisdiction, of course, the circumstances of the request. And keep in mind that confidentiality is our ethical responsibility to protect the information that is shared with us in our professional relationship with patients or clients. While privilege is a legal rule that protects the communications between mental health professional and their patient or client from disclosure in legal matters. Okay. Now, if you were subpoenaed, for instance, for deposition testimony, which is different from court testimony in that it's conducted outside the courtroom, outside the presence of the judge. Contact your professional liability insurer to consult about potential coverage options if that's the case. You may have the ability to tap into some legal resources to help you prepare. Now, if despite attempts otherwise, you must appear to testify, either in response to a subpoena that was accompanied by authorization from a patient or client, or perhaps through a court order that compels you to appear. Regardless whether it's a deposition or a hearing in court, consider the following steps. Start by assuring that you have authorization to disclose the relationship you have with the client patient, as well as the information that will be discussed. I'll often recommend making your authorizations as context specific as possible. So a disclosure of records isn't the same as disclosing information verbally in court. Clarify your fee arrangements as soon as possible. Now, ideally, fee arrangements for charges or time spent outside of therapy sessions clarified in the informed consent, which would allow you to remind the patient or client about this agreement when you receive a request for testimony. And if a patient or client pushes back about payment, remain calm and remind them about the fee arrangements and the agreement you had at the outset of treatment. You can also inform them that you're open to alternative payment arrangements if they're available, but otherwise, your expectation is that you'll be paid for your time as agreed upon. Now, if you are ultimately informed that reimbursement is going to be limited to that of a fact witness, which I think commonly is around $20, $25, you can have yourself maybe a decent lunch. You may wish to consider consulting with a local attorney or someone who specializes in healthcare law, just to determine if there are any options available to challenge this decision. Now, in terms of before testimony occurs, prepare, review, and scrutinize your work to prepare for potential avenues of questioning. Ask yourself, if I was in the role of the attorneys in this situation, what questions would I ask? And what are they likely to want to know? Now, when you're testifying, communicate as an educator rather than as a scientist speaking to another scientist. In other words, speak plainly and avoid jargon and unfamiliar language. Breathe, remain calm, control your pace. And in other words, let's practice our mindfulness skills and tap into those. And I think one of the most important things we can do is stay within our role. We acknowledge limitations that exist, those perhaps that are inherent in the role that we're performing as a treatment provider. Perhaps it's acknowledging the limitations on the information we have access to. But by understanding the limitations, this allows us to understand the parameters of our role and to clarify that when need be. And one way that I have recommended, and I believe really is helpful to anchor us in terms of where our boundaries are of our role, is looking at the treatment plan. And by knowing what has occurred in treatment, what we're focusing on, questions that fall outside of that role are going to become more evident. Okay? Now, also remind yourself that attorneys that are questioning you are simply advocating for their client. And while it sometimes, depending upon the attorney, may feel like a personal attack, it's not personal. They're simply just advocating. And finally, consult with experienced colleagues. Perhaps this would allow you to role play, create some expectations for where questioning may go. And then you can, of course, practice your responses.
Yeah, terrific. Thank you, Mark. I do want to just say, you mentioned the need for a fee agreement. And I want to say, in our template, which is available online, our sample informed consent template, there's some sample language about fees, and in particular fees if you get called in to testify and that kind of thing. So we encourage you to take a look at that as well, because that's a really great point. Julie, anything you want to add to that?
Not much, just real quickly, this is a really good reason to call us. We talk to people all the time, sort of talk them through what their role is and what their role isn't, and how to not answer questions in a kind way. So this can be very anxiety provoking for folks who are not experienced or who never want to be in a courtroom. So don't hesitate. I would say every day that I do calls, I have at least one about someone who's been subpoenaed and does not know what to do or what to say on the stand. They wonder if they need their own attorney. Just consult with us or with your own risk management provider and get some ideas, because it's really not terrifying, and you're not at a lot of risk as long as you understand your role and stay within that.
Yes. Yeah, perfect. Thank you. So then the last question goes to you, Julie, before we start taking the live Q&As. And as you know, and many clinicians know now, the federal public health emergency expired on May 11th. And so the question is really, what does that mean in particular for practitioners? So I'll let you dive in.
Great question, and another hot topic these days. As an initial matter, I just want to clarify that the federal public health emergency is a federal thing. It is not the same as the state waivers that were in place. So I think a lot of us were practicing under waivers of licensure especially in the early days of COVID. States waived a lot of requirements and allowed a lot of interjurisdictional practice. If you think that you're currently operating under a state level waiver, you need to double check, because I don't know of any of those that are still in effect. So the state waivers about licensure and interjurisdictional practice are separate and distinct from the federal public health emergency. So the PHE, many of the flexibilities related to that were related to telehealth and Medicare. So that's really what we'll focus on. Some of these things were extended, some of them have expired. The one that has expired that I think is most important for providers to know is in the early days, HHS, it said they were going to, I think, have enforcement flexibility related to HIPAA compliant platforms. What that meant was you were free to use Skype, FaceTime, the free Zoom, any kind of teletherapy platform that you could. And I think the push was just to get people the services they needed, and we weren't all set up with accounts with HIPAA compliant platforms. At this point, those flexibilities have ended, although they have given a 90-day transition period. So you have until August 9th of this year to start using a HIPAA compliant platform. And what I mean by that is it's a platform that will meet HIPAA standards for security. The free Zoom does not do that. Skype and FaceTime do not do that. There is a Zoom for healthcare providers. There's Doxy.me. There are many, many platforms out there that are appropriate. The thing you want to look for is a business associate agreement with the vendor. That will indicate that they are committing to following HIPAA standards in terms of security. So I think that's the big one that people really need to be aware of. You need to start looking now and transitioning to a new platform if you've been taking care of that flexibility in terms of teletherapy platforms. A couple of flexibilities that were extended permanently include Medicare flexibilities for telehealth for behavioral health. So at this point, you can access telehealth from anywhere in the US, not just rural areas under Medicare. It used to only be restricted to certain rural geographic areas. Patients can also be in their home to access services. Previously, they would have to travel to a clinic or a health facility to do telehealth services under Medicare, which doesn't make much sense. But at this point, that is no longer a thing. And there are flexibilities for allowing audio only technologies rather than audio and video if the patient can't use both. So those have been extended permanently. Those are on the books for good. One that was extended only temporarily is the in-person visit requirement. So for Medicare patients, you are supposed to see them in person within 6 months of the initial telehealth visit, and then one in-person visit annually after that. That was waived for the PHE, and it has been extended through December 31st of next year, 2024. It could be very disruptive to people's practices if that gets reinstated, because a lot of folks have, either through SIPACT or some other way, have been working with folks who aren't geographically close to them, who may not be able to come in person. So we'll be monitoring that really closely, and hopefully that'll be extended as well. But for now, you're good to go through next year in terms of not needing that in-person visit. Excuse me. The PHE doesn't directly affect private insurers. It really affects Medicare and CMS, but a lot of private insurers follow what Medicare does. But you do want to make sure that if you're working with private insurers or your patients are getting reimbursement, that they check with their insurance companies and make sure that reimbursement hasn't changed or that requirements haven't changed, that they haven't instituted an in-person requirement or something along those lines. And lastly, I will say, with the PHE ending, the Centers for Disease Control is not getting the data that they were getting previously about community transmission levels. They had been basing their recommendations on protocols for masking and the like on those transmission levels. So that data is no longer available. The CDC says that we as providers should find local places to get those metrics and then make our decisions about whether to use masks or other protocols based on the data that we're able to find, which is pretty tough. But basically the CDC is sort of leaving it up to us at this point to figure out what's the transmission level in our area and what protocols do we want to put in place. We've got a couple of links in the chat that direct you to some of the FAQs and fact sheets from HHS about this matter. So it's hard to decipher, so don't hesitate to reach out if you have questions about that as well.
Yeah, terrific. Thank you, Julie. Mark, anything to add on that?
I don't. I think Julie did a great job.
Covered it. That was good. Okay, so we're going to go ahead and dive in then to the live questions. And this first one is really a bit of a practical logistical question. Is there or are either of you aware of a website that summarizes various telehealth regulations for all states? Either of you, Julie, you want to jump in there?
I think there is one, and I can't think of it off the top of my head. I know that we, as the risk managers, have exchanged some websites with that information. There's nothing that I know of that talks about the interjurisdictional practice, the temporary practice laws into different states. But I think there are some, and unfortunately, I can't pull it up in my mind right now. I don't know, Mark, if your brain is more intact than mine at this point.
No, I have the same memory, but I don't know the site offhand. But I think as a default, if you can't find it, then reaching out either to the board, or I will often recommend the leadership of a state psychological association. I find that they're very responsive. They have their finger on the pulse of the developments in the state, so they can be a really great resource.
Yeah, and I actually am not, I don't know that there is one that covers all telehealth regulations. I think there's some that cover some, and certainly during the pandemic, my recollection is there were, APA and some others tried to put out to keep us updated. But again, since so much of that has expired, I'm as of now unaware of one that has like all the regulations. So hopefully that will be developed at some point, but I think it's a little bit piecemeal right now. So yeah, calling, and Mark, I like your suggestion about getting additional information too. So, okay, can you address then risk management associated with walking outdoors therapy or walk and talk therapy? Mark, do you want to start on that one?
Sure. Yeah, I think it's a great starting point. I'd recommend going to trustinsurance.com. And once you get to the main page, search for the Resource Center tab. Once you're at the Resource Center, look at the document library, and you will see that there's actually a sample document that is provided in the document library specific to walk and talk therapy. Now, a few of the things that you want to keep in mind is the unpredictability of the environment that you're going to be conducting therapy in, where there can be hazards that can't be avoided or may not be predictable, as well as interactions with other people or even animals you may not anticipate. And so being aware of those potential developments and making sure that you have a plan for those events should they arise. I think one of the more common ones, especially if you're going out where the public is going to congregate, is potentially bumping into somebody that the patient knows. And you want to make sure that you have a plan for addressing this. You also want to make sure that if you're discussing things in a public forum, that you're mindful of confidentiality and that you're not disclosing it. And there's also nowadays with the technology, people can record from very far away, both video and audio. And so you want to be sensitive to that and make sure that the patient can make an informed decision about if they want to participate in this type of therapy.
Yeah, terrific. Julie, anything to add there?
Only thing I'll say is that walk and talk consent does have a lot of information about COVID protocols that are going to be in place. It was originally designed earlier on when we were still doing 6 feet away, wearing masks, all of those things. So definitely modify it to reflect what you are actually doing. It's possible that the whole middle section of that form is not relevant today, and hopefully will never be again. But it does address the other things that Mark talked about, and I think it's a really nice document and helps you think about the things that you might not have considered in terms of what are the risks and unique aspects of this. But it's a great option, and especially as summer's coming up, I think a lot of people wouldn't mind taking a little walk outside instead of sitting in their office.
Yeah, and I think two important things to remember, and I believe these are covered in the document, but one is about the formality or lack thereof. It can feel much more informal to do walk and talk therapy, which has its benefits, right? With minors, sometimes it can get them to open up, but you want to think that through and be careful about boundaries and have discussions with your clients about that. And then the other piece that comes to mind very quickly is the health issue, right? You may want to ensure perhaps that you have a doctor's pass, or certainly have communications with your client that, look, we go at your pace. If you ever want to slow down, we'll slow down, So thinking about some things like that too, I think is really important when you're doing that. So, all right, next question. When can minors consent to psychotherapy? Are only emancipated minors able to consent? And are the criteria different from one state to another? Julie, how about you start with that one?
Yes, the criteria are very different from one state to another. This is a very state-specific kind of question. Some states have age of consent laws as low as 12 years old. I'm in one of those. Colorado has a 12-year-old age of consent law, but it doesn't just mean that when a parent brings their minor client in, that minor, that 12-year-old is consenting to their own care. The law, at least in Colorado, is designed for situations where parental involvement would be unsafe in some way or would be contraindicated. And so I believe California, we model our law here in Colorado after California's. Both of them require that the clinician make a determination that the minor is in need of this care, that they are mature enough to manage their own mental health care. You are required to have a conversation with the minor about the importance of involving their parents and almost have them convince you why it's appropriate not to. And all of these things need to be documented. And so this is a really important state-by-state analysis. And so if you have a question about this, absolutely consult with an attorney or consult with one of us and we'll look up your state laws. But I think for the most part, these laws really are not intended for the typical private practice scenario where mom or dad brings the patient in, they're going to pay for the minor's care, they're there and involved, and then you still require the 12-year-old to sign the consent form. And it's just not, that's not the scenario that's imagined here. These are for situations where kids need care but can't get it for some reason because parents will object, and it allows the minors to consent under certain conditions. So I would say ask the question of someone in your state to clarify if there is a minor consent law, and if so, are there specific documentation requirements or clinical judgments that need to be made before you can allow that minor to consent to their own care. You know, it brings up the question of confidentiality. I think generally if a minor consents to their care lawfully under one of these statutes, then the minor holds privilege on their own behalf rather than the parents holding privilege as the personal representatives of the minor. It can get very complicated very quickly. So I would say that's a situation where if you don't have absolute clarity on that, definitely consult, because if a parent finds out that you were providing services to their kiddo without their consent, they may get very upset about that, and you want to have a solid legal basis upon which you made that decision and moved forward.
Mm-hmm. Yes, I agree. Mark, any additions there?
No, I think that when it comes to different jurisdictions, you'll sometimes see professional judgment, and then you'll see a standard that's embedded within that law. And so if you do get the thumbs up that your interpretation of this is correct, the consultation is duly suggested, I think that will also speak to the importance of documenting the rationale for why that standard's met. So if there are questions that arise down the line, you want to be able to show that you have support, that you considered the standard, and that it is met based upon your professional judgment. In other words, be able to show your work.
Mm-hmm. Yeah, and that's a great point. And I think too, it's important to keep this in mind if you're doing cross-jurisdictional work, if you're working into another state, because as Julie said, different states have very different laws about this. And it may also have implications if a minor is the one who has consented. It could have implications for record releases, again, depending on the state law. So there's much more here that we can't get into, but just a couple of things to keep in mind, and definitely, you know, consult frequently on that. The next one is a question related to psychological eval with an inmate. So Mark, I'll toss this one your way because I know you do a lot of forensic work. But really the question is, in this case, she was doing or the clinician was doing a psych eval with an inmate, received consent to speak to mother, received written consent to speak to mother, verbal consent to speak to father. And the question is, she did end up speaking with both of them, but should there have been written consent for both parents?
It's a good question. And I think it's nice that you're thinking about this, because I think it's a nuanced question. And I've actually had some conversations with colleagues about this very issue, and there's been some difference in thought. But I think first and foremost, I'd be curious to know who the referral party is. So for instance, if it's a court and your appointment is something that is in the public domain, then you reaching out to collaterals, I would argue, doesn't necessarily require you to get that consent. One, because you're ordered by the court, and two, because it's in the public domain as well, that your relationship to that individual is already public information. So you're really not disclosing very much. And then when you're asking questions, hopefully, as long as you're asking questions in a way that's a one-way street, not disclosing information to the party you're interviewing about sensitive information they may not have access to, then I would think that that would be fairly safe. However, if it's not public and say it's an ex parte evaluation or the individual requested, I think that it's best to be as formal as possible so that if the questions arise, then you can show that you have their written consent to reach out to these individuals. I don't see it as extremely high risk, but if it's contentious, it's a forensic evaluation, low-hanging fruit gets a lot of attention. So you want to do everything by the book. So while I think documenting that you had verbal consent, I think that would be fairly protective. At the same time, we want to avoid any low-hanging fruit and gravitate towards the more formal remedies when possible.
Mhm. Yeah, avoid a he said, she said if possible.
Absolutely, yeah.
Julie, any addition there?
The only thing I'd add is I agree with everything Mark said. And if you do end up in a situation where you have verbal consent only, not only would I document that you have that consent, but why were you not able to get the written consent, right? Anytime you're kind of deviating from what the standard is, you want to explain why. So I think that will add an additional layer of protection if in that kind of situation.
Yeah, that's a great point, Julie. Yeah, that's great. Okay, so next question. I have a billing office that is a separate business that I pay a percentage to. Last year, that company sold to another billing person. Should I be doing anything to ensure they follow HIPAA, confidentiality, ethical guidelines, etc.? What do you recommend? Julie, you want to start?
Yeah, so anytime you're using an outside vendor who's going to have access to PHI, protected health information, you want to have a business associate agreement with them. That assumes a lot of questions we answer assume that you are a HIPAA covered entity because most of us are. So assuming you are a HIPAA covered entity, you want a business associate agreement with the vendor that you're working with. Now, if they've sold to another company and all of the contracts that they have been assigned to that new company, you may be protected, but I don't see any harm in asking for a new BAA with the new company to be re-executed. It's just a belt and suspenders approach that I think it provides a little more certainty that everybody understands that that billing company is explicitly agreeing to be bound by HIPAA standards and to be held accountable if they're not.
Mm-hmm. Yeah, I agree. Mark, any addition?
The only thing I would add is even if you're not a covered entity, then it really won't harm you to consider yourself as one and act accordingly. I think it offers some heightened protections.
I agree.
Right. So here's a question I'm sure we will be getting many, many more times, but are there any standards related to the use of AI application in therapy, artificial intelligence? Apparently APS in Australia has been developing such standards. Do either of you know of any standards now, or can you speak to where that's at currently or what we should be thinking about briefly from a risk management? I know we could do a whole webinar on that only, but if you have a few very brief thoughts on risk management, that would be terrific. Mark, do you want to start?
Oh boy, I was wondering who was going to get that one. The first thought that comes to my mind is I don't really know. I think because I don't know exactly where it's headed, what it can do. I'm a bit naive when it comes to it. I'm starting to scratch the surface myself. I have heard some anecdotal reports of attorneys using it to write briefs, or a psychologist who used it to write an evaluation report, but which I think has clear ethical implications. So depending upon how it's used, of course, confidentiality considerations are important, the basis of being able to show our work. I think there are a lot of implications, but at this time, I don't know too much of how it's going to be implemented in order to answer precisely, because it really is kind of the Wild West at this point. And we're just kind of waiting to see how the chips fall and then be reactive, which is not a comfortable place to be. So I'm one of those people who likes to wait and see so that I can see some of the potential ramifications and then prepare for them and decide whether I want to move forward. But I'm always curious to learn more. Julie, is there any? Julie, Lisa,
I think it's fascinating, and I agree. Nothing. It's so brand new right now, and we're still just kind of wrapping our heads around what it can do and what the implications may be. I don't know that we've developed any actual standards yet. What I would say, and I'm echoing what Mark says, I've heard the same stories about people using it in ways that are just, to me, blatantly inappropriate, right? You cannot substitute the judgment of AI for your clinical judgment. So do your own work. And if you're going to use one way I did hear of it being used, which was kind of interesting, I thought, was someone asked the chat GPT to create a treatment plan for a certain patient with a certain, cognitive behavioral therapy treatment plan for anxiety, just to see what it spit out. And it actually had some decent ideas. So I think it can be one of many, many sources of ideas and thoughts, but the work product must be yours. You must have exercised your clinical judgment in deciding whether to use anything that's generated from AI. And, you know, there are a lot of implications in terms of confidentiality and privacy and, you know, biases and prejudices that are embedded in the AI. I mean, there's a lot out there. As we know, laws and regulations and standards are almost always reactive, right? They will follow when the thing is happening. So the thing is happening now and we don't have standards for it. I'm a risk management consultant. I'm going to say, don't use the thing yet until we figured out how to use it in a safe and effective way. But nothing will replace our clinical judgment. Therapy is a science and it's an art. And I don't know how good AI is going to get, but it's never going to replace the human element, at least not in a therapeutic relationship.
Yeah, well, and I think, you know, one of the themes that seems to be occurring today is this idea of what do we do with new and emerging technology, new and emerging treatments, ketamine-assisted psychedelics treatments, those sorts of things. And you know, one of the take homes I think really is be cautious, really think this through. Don't just jump in. And, you know, it is exciting and we all want to take advantage of it. And it might have some true benefit for our clients, which is fantastic, but be conservative to start, be really careful, consult, you know, before you dive into some of this. And Julie, I just want to underscore one of the things, I think, Mark, you mentioned it too, but this issue of confidentiality. If you are entering in patient information into ChatGPT, you know, that's data, it's holding all that information. So you have to be very careful about what kind of information you are inputting, and certainly not sharing confidential PHI. I think is very risky. So, you know, if you're going to do it, do a lot of research, get some consultation, and then jump in a cautious manner until we start to see how this unravels. And I would love it if, I don't know if this is the case, if it's even on tap for the ethics, you know, the new ethics code, but it'd be really nice if there were some guidelines in the new ethics code about this too, because it's certainly coming down the pike. So, okay, this might be hopefully fast and easier than some of those. How do you dispose of test materials, say books, manuals, etc., when other local professionals are not interested? Do you shred them, or how do you dispose of them? Mark, I'll start with you.
Yeah, assuming, of course, you don't have colleagues that want them. Sometimes you get colleagues that really want old DSMs or things of that nature for whatever reason. But in the situation you offer, that's not the case. So there are secure destruct companies. You can find them fairly easily. Those that will dispose, they'll often incinerate. So they work with hospitals commonly or other practices, and you can contract with them. You could have them sign a BAA just to make sure that they're going to have secure practices with the disposal. But there should be plenty of options available for destroying completely and making sure it doesn't fall into the wrong hands or make its way to eBay.
Yeah.
Julie, anything you want to add there?
It makes me think of the very first question we started with when we were talking about reasonable measures to protect test security, and it's, you know, just tossing it in your trash can is probably not enough. We do not want these things to be widely disseminated because it will invalidate them. So some sort of secure destruction, and like Mark said, there are companies that do this, and so I would take. You want to be able to argue that you took some kind of reasonable step to protect that information, because that's our obligation under the ethics code.
Yes. And speaking of taking reasonable steps to protect information, the next question is, how do you handle clients unexpectedly taking pictures of test stimuli? Julie, you want to dive in? I think I've given Mark several in a row here, so I'll come back to you.
I think a really good rule is you can't bring your cell phone into the testing center or to the testing area. I mean, make that a clear prohibition at the outset. And, you know, like other, you know, I think about people who bring their cell phone in and record a therapy session and the therapist doesn't know. I mean, there's no way to actually prevent all of this, but we'll go back to reasonableness, right? I mean, you need to set that expectation. You need to explicitly say, perhaps in your informed consent, you will not take pictures or reproduce any of this. And make that the standard, monitor it as best you can. And we're not going to be able to pat down everyone and make sure they don't have anything with them, but we can have people sign something saying they agree not to do this thing. And then if it happens, at least you will have taken that step and gotten them to agree to something, and then they broke their own agreement. I'm not sure there's much more that you can do. And I know, Mark, you do a lot more assessments. So do you have any secrets on that one?
No, I don't. I think that your idea of leaving the cell phones behind, if possible, shutting them off, or supervising the testing to make sure that nothing untoward's happening. Also having it in an agreement. That's something that I've actually incorporated into mine, even in incarcerated samples, just because it's so easy for people to have it there. And I feel like it will meet the reasonable standard. So I think that those are good ideas. And sometimes it's really not possible to control the actions of others. Even with a protective order, I've known of some attorneys who will disseminate it contrary to the order. But what you've done is you've taken reasonable steps to try to protect it. And when people act contrary to that, there's only so much you can do.
Yeah, terrific. Thank you both. I was looking at the questions to see if I could squeeze in one more, but I see Jana here, so that means we can't. We tried, but Jana, I'll turn it back over to you.
Yeah, well, and I came on a little bit early because I wanted to make sure that I know that there was a question about, is there a central place for telemental health laws? And we put in the chat box, there's a law firm called Epstein, Becker and Green, and they have an app that you can download that has all the telemental health laws on it, and they keep it very updated. We put in the chat box the link to it, and I just wanted to call people's attention to it in case they missed it. But we've worked often with Kevin Ryan. He actually was a speaker for us at one of our NP's National Practice Conferences, and he's going to be a speaker again this coming National Practice Conference. And he's helped us to make others aware of this. And I believe that Judy has put that in the chat box again. So, well, I want to thank you, all three of you, very much for your presentation today, as always. You shared an awful lot of information with us, and you've covered quite a bit of varied ground today.